Hello, and welcome to Williams Mullins Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets, such as patents, trademarks, copyrights, trade secrets, and related topics. I'm your host, Carmelle Alipio, associate in the IP section of our firm. I'm joined today by Rob Van Arnam, chair of our intellectual property practice group here at Williams Mullen, and a partner who counsels and litigates Telephone Consumer Protection Act, or TCPA for short, matters. And that's our topic today, recent TCPA litigation trends and orders. Hi, Rob. I hope you're doing well. I'm glad you could join today because I know you have been tracking and litigating TCPA cases. How are you doing?
Thanks, Carmelle, for having me. And indeed, the TCPA litigation matters and trends are interesting. I know you've been tracking those as well.
Well, it may be good to start with recent TCPA litigation cases and trends, since you mentioned them. I know there's been a significant volume of TCPA cases over the last several years.
Yeah, unfortunately, the significant number of TCPA cases has continued. And what often happens in the laws starts off with a good faith effort to attempt to protect consumers and reduce number of harassing telemarketing messages. But it's become a cash cow for the plaintiff's bar and essentially has been harassing litigation on companies. And I think in part the statutory damages of up to $1,500 per violation and the possibility of class treatment for those cases has motivated plaintiffs to continue to bring such cases.
That is a surprise. I know the Supreme Court had a significant ruling in Facebook versus Do Good in 2021. How did that affect TCPA litigation?
Yeah, so in Do Good, the court curbed in a good way the overly broad interpretation of what constitutes an auto dialer. And it said the auto dialer is, part of TCPA, an automatic telephone dialing system, or ATDS, did not include, as the plaintiffs had long argued, virtually all modern cell phones. The Do Good decision also rejected human intervention as a relevant factor in analyzing whether a device constitutes an ATDS, because it, somewhat logically found that human intervention was always involved, and it didn't want courts to have to get into the business of drawing such fine lines. So while the Supreme Court rightly rejected plaintiffs' arguments in that case, it also sort of foreclosed a defense, which was that of human intervention. So after that, there was a dip in cases, but they continued, and a lot turned on, certain cases of whether an ATDS was used to send text. In one case, for example, the plaintiff alleged that the defendant had used an ATDS to text him because the messages were not sent by a live agent. And according to the plaintiff, that meant a one-sided conversation. He couldn't get responses or answers to his questions. And that case actually ended up settling for a fair bit. And other cases dealt with the same issue. And the Fourth Circuit, because I know a lot of our listeners are operating in the Fourth Circuit, in Guthrie versus PSG Mortgage in 2023, it cemented the notion that an ATDS must be used, not just that it's something the company has. And the plaintiff in that case failed to allege the defendant actually used those capabilities to call the plaintiff. So I guess in sum, the Do Good decision slowed down TCPA litigation, but not for long. And a few trends developed. Plaintiffs found paths around that case and focused on other aspects of TCPA, like pre-recorded calls or SMS messaging. And state laws were passed as well to try to fill in the gaps that Do Good had carved out. Some recent state examples, Florida has been a big one, but also Washington, Oklahoma, and Maryland. And then in addition, plaintiffs have just enacted new and different tactics to evade consent by, for instance, using other numbers or recirculating other numbers.
And how does that work?
Yeah. So, well, for instance, a company would get, as they're required, advance consent from a name and telephone number that registered for messages in their system. But then a different person would claim to own that number and have never consented. And so somehow that number was passed or sold or something to the new person. And this is a newer phenomenon with serial plaintiffs. But speaking of consent, you've been tracking the FCC orders and the one-to-one consent rule and opt-out requirements. And I know we want to get to that too. What's the latest on that?
Yes, before I jump into that, I think it would be helpful to remind listeners that the main considerations in defending TCPA cases involve a business's consumer records, consent records, and call records, with consent records being the highlight of the recent orders that you mentioned from the FCC. So, turning to the most recent case on the FCC's one-to-one consent rule, which, as most of our listeners may know now, is not effective, Insurance Marketing Coalition Limited versus the FCC, which made its way to the 11th Circuit. The 11th Circuit analyzed the FCC's one-to-one consent rule, where the rule required businesses to obtain consent on a one-to-one basis, meaning that businesses couldn't bundle consent with other businesses, and a business needed to collect consumer consent on its own if that business itself planned to send automated marketing calls and text messages to the consumer. The 11th Circuit found that the FCC had exceeded its statutory authority under the TCPA because those one-to-one restrictions impermissibly conflicted with the ordinary statutory meaning of prior express consent. It's important to note that the court found the TCPA requires only prior express consent, not prior express consent plus. And in this case, the court interpreted prior express consent as meaning consent that's clearly and unmistakably stated by the consumer. So according to the 11th Circuit, the FCC's one-to-one consent restriction could not be squared away with this plain understanding of what prior express consent means. So the one-to-one consent restriction would have imposed a prior express consent plus restriction and prohibited businesses from making automated calls or texts to consumers who had previously clearly and unmistakably stated that they were willing to receive marketing calls from multiple businesses at one point of consent collection, because consent had to be given independently and separately to each business. Now, since the 11th Circuit's order vacating the FCC's one-to-one consent rule, the TCPA's recently effective opt-out rule should be at the front of a business's attention. Many of our listeners are aware of the requirements to comply with opt-out requests already, due to it being required under many state privacy laws. The FCC's opt-out rule similarly makes it easier for consumers to revoke consent. So the opt-out rule now codified the FCC's positions on two issues: consent revocation and confirmation of the consent revocation. And I'll talk about each of those issues in turn. So first, the opt-out rule requires businesses to comply with consumer consent revocation requests when it comes to automated calls and texts, and provides clarity on what constitutes a reasonable means of revoking consent, our favorite standard. A consumer may revoke prior express consent, including prior express written consent to receive calls or text messages, by using any reasonable method to clearly express a desire to not be further contacted by a business. So this means a consumer can use words like stop, quit, end, revoke, opt out, cancel, or unsubscribe, which I'll refer to as the revoking text for short, and send the revoking text in reply to an incoming text message or pursuant to a website form or telephone number designated by the business. Any revoking text constitutes a reasonable means per se to revoke consent. So if a consumer uses any of these words via text, on a call, or through a designated website, the consumer's consent is considered definitively revoked, and the business may not send additional automated robocalls or texts. If a reply to an incoming text message uses words other than the revoking text, the business must treat that reply as a valid revocation request if a reasonable person would understand those words to have conveyed a request to revoke consent. So for example, I don't want these messages anymore. No, stop, quit, end. That's not in that sentence, but a reasonable person would understand that statement to mean they want to be taken off the list. If a business does not allow for reply texts, it must provide a clear and conspicuous disclosure on each text to the consumer that two-way texting isn't available. And the business must provide reasonable alternative ways for a consumer to revoke consent. Businesses are also required to honor consent revocations made in a reasonable manner within 10 business days of receipt of that request. Now, turning now to the second issue. Second, the opt-out rule codifies a prior FCC declaratory ruling that a one-time text message confirming a request to revoke consent from a consumer is permitted under the TCPA. And it's permitted as long as the confirmation text only confirms the consumer's revocation request and doesn't include any marketing or promotional information. The confirmation text must also be the only additional message sent to the consumer following receipt of the revocation requests. Confirmation texts that are sent within 5 minutes of receipt of the consent revocation request are presumed to fall within the consumer's prior express consent. If it takes longer, though, the sender will have to make a showing that the delay was reasonable. Now, if a consumer has consented to several categories of text messages or calls from the business, the confirmation message may request clarification as to whether the revocation request was meant to cover all messages. However, the business may not send further texts requiring consent without any response from the consumer. So while insurance marketing at the 11th Circuit was a significant ruling for the TCPA, are there any other recent cases that you've been tracking, Rob? And are there any key takeaways that companies should consider in defending such cases?
It's Carmelle. Insurance marketing was probably the biggest and most recent case to that level. Probably don't have time to cover too many cases, but a very recent case of Hulse versus Zibango Inc. is interesting. And that's a Seventh Circuit case just issued March 17th, 2025. So just literally a few days ago. So the TCPA prohibits telephone solicitations to residential telephone numbers and on the National Do Not Call Registry. But what counts as a solicitation? In Hulse, the plaintiff allegedly received about 20 calls and text messages from FoodSmart, the defendant. And FoodSmart contracted with a healthcare plan to provide free consultations to plan members. The communications discussed FoodSmart's services, which were available to Hulse, an important fact, at no cost through a state and Medicaid-funded healthcare plan. So when Hulse used FoodSmart services, his healthcare provider, not Hulse, would pay FoodSmart. So FoodSmart used that to move for summary judgment and argued that because its calls and text messages were for purposes of providing Hulse with information about a free service, they did not encourage the purchase of a good, service, or property, and therefore couldn't be solicitations under the TCPA. And Hulse countered that his health insurer would have paid for their services if he had accepted them, and the calls and messages were, therefore, of course, initiated for the purposes of encouraging Hulse to purchase FoodSmart services. FoodSmart prevailed in the Eastern District of Wisconsin, and Hulse appealed. And the Seventh Circuit focused on the TCPA's definition of telephone solicitation, and that's the interesting point here. And that meaning the initiation of a telephone call or message for the purposes of encouraging the purchase or rental investment of a property, good, or service. And the majority sided with FoodSmart and held ultimately that while the purpose of the communications was to encourage plaintiff to use FoodSmart's service, it does not follow that their purpose was to encourage them to purchase FoodSmart services. And that was because the services were available for free. So the key in that case was that because services were free, they couldn't constitute telephone solicitations. And that has ramifications on a lot of companies who may offer a free service or something. And so that's pretty useful for defendant companies to, monitor that going forward. I think in general, there's some key takeaways. First, we talked about the the volume of these matters is going to increase. I think after Do Good, there was a slight dip, but as we've seen, they have picked up and expanded. And that's in part because serial plaintiffs and plaintiffs' counsel bring the vast majority of these cases. They're repeat customers or folks who bring these. And I think that's because they assume they could get big settlements or trial wins. And the evasion of consent, I think that's a new tactic that's going to continue. And that means, as you suggested, that companies really need to have meticulous records about who consented and when, and the record that they could pull up on that, and maybe even add requirements that the person giving consent must own the phone number at issue, so there's no recirculation later on. Another thing is, settling, which often makes economic sense, can make you a target for follow-on cases because there are 10 or 12 plaintiffs' counsel and a lot of the same repeat plaintiffs that bring these cases. They know who settle and who may be willing to pay money. And so for that, it's important to gauge competent counsel who have experience in this practice, and also with plaintiffs' counsel, so they can kind of know their MO and how they operate. Another takeaway may be to scrutinize class definitions. So critically examining class definitions can highlight issues with class members being able to demonstrate concrete harm, and you could defeat class on that basis and reduce exposure. That's a big one. And I think you were suggesting this too, enhance compliance practices. So, robust compliance for consent is the best way to avoid litigation, or if sued, to be able to defend yourself and show what you did to get prior express consent, maintaining up-to-date do not call lists, auditing telemarketing campaigns, making sure any third-party vendors are complying with this, and staying up to speed on all TCPA regulations.
That makes sense. And I'll add to that last point you made that, where a plaintiff could argue that there was non-compliance with obtaining consent related to a technical issue or software issue, the TCPA doesn't care about intent. It's not relevant under the statute. So making sure that everything in-house is running in order is really essential here. Thanks, Rob. That will wrap up our discussion on TCPA compliance and recent litigation updates. I'd like to thank Rob Van Arnam again for joining me on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please feel free to contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Be sure to subscribe to be notified when our next episode drops. Thanks for listening, and until next time.
This podcast contains general, condensed summaries of actual legal matters, statutes, and opinions for informational and educational purposes only. It is not meant to be and should not be construed as legal advice. Listeners with particular needs on specific issues should retain the services of competent counsel. For more information, please visit our website at www.williamsmullen.com or contact any member of our team.